Hi everyone, my name is Milla Pennanen and I'm the Executive Director of Game Makers of Finland. Welcome to join our webinar about non-competition law and the Working Hours Act. This event will be hosted by Maria Jauhiainen, who is a lawyer from the Union of the Professional Engineers in Finland. So no more words in this beginning, so Maria, the stage is yours.
Hello everybody, my name is Maria Jauhiainen, and as you can see, I'm the lawyer in Union of Professional Engineers in Finland, and I have been here for a while, but I will not tell you how many years. Let's say a while. But a while to learn how working hours in Finland and non-competition agreements especially can make some problems in trying to work here, and especially trying to change jobs in Finland, mainly to do with the non-competition agreements. And then working hours, I have to tell you, it hasn't been easy for a lawyer to get on grips with that. So for a layperson, it can be a little bit trickier. But if somebody knows it very well, then you can commend yourself on that, on cracking the big coconut in Finland, that is their working hours. So that's why we're going to go through the Working Hours in Finland Act in detail, and hopefully you will learn something new about it and know what you are entitled to and what you're supposed to be doing. So first I will talk to you about the renewing of the Working Hours Act. That was started, I think, in 2016, and it was ongoing in 2017, and some parts of it came into force in 2018 and the rest of it last year. So it was a long time process, but we got something really good things in it, and mainly to do with zero working hours contracts and flexible work and working time bank. Some of these issues were new things in the law, and I will talk to you more about that later on. So a little bit behind the reasons why we started renewing the Working Hours Act. The main reason was that it was a little bit outdated, especially when it came to working time arrangements and how flexible they were. But we also wanted to have sort of flexicurity in the system, so that the clauses in the law would be flexible, but also guarding the rights of the workers. And sometimes, and many times, it is forgotten that the Working Time Act or Working Hours Act is actually a law to protect the employee from the employer, and also in some cases from themselves, because some people do tend to work too much. So also for that, so that the employer has some tools to intervene if somebody is doing too much work and so forth. But its aim was to make the law meet the demands of today, of the 20th century, and also provide the protection for all workers, also experts and senior salaried workers included, and also taking health and safety aspects into account. And all of this was based on the Working Time Directive from the European Union, and that has been in the pipeline in the EU now. I think the renewals of that directive has been there now for, let's say, 10 years. It always pops up and then it goes down, and now it has popped up again. So let's hope that something will happen with that directive in the future, and for the better. Of course, not for the worse, but for the better. And here is also some background, and also for your knowledge, which is, I think, good to remember. that when they were renewing the Working Hours Act, they went through also studies that were made into how working too long will affect your health. And working too long hours is linked to, inter alia, to many chronic diseases, heart diseases, and digestive diseases, what have you. And the risk increases after exceeding 40 hours per week, but it's especially high when 50 hours of work per week is exceeded. So it's very, very important not to work too much. So and also what was talked about was the working life balance, so that you can also have free time, do something with your family. And also studies show that usually 8 hours is the maximum time for a person to be really effective when doing their work. After that, it's not so effective. So there's no use in doing more work when more results can be achieved in working less time. So this is the background. And like I said, flexicurity was in place here when talking about these things, and the new law seeks to meet the different working time needs of the companies also, but also providing protection for the workers. Also, work at home is no longer excluded from the law, which used to be the case. So it was regarded that the employer cannot supervise the work that is done at home. But of course, nowadays, everybody's working from home, or most of us, at least for a while. So luckily, it was excluded from the exclusion list, if I can say it so. In a tricky way, but working at home is now included in the scope of the law, and it is no longer either tied to the actual workplace, what it used to be, but working time is time spent at work, doing work anywhere. And it was really good that we got the teleworking falling within the scope of the Working Hours Act, and that it helps with the modern situation. But in contrast to this, travel time is still not yet counted as working time, unless one is also doing work whilst traveling. So working travel can be compensated. I will talk a little bit more about that later, but it doesn't have to be. And when I say here travel time, it means traveling in your free time. And if you have your normal working day, when you start traveling, let's say at 8 o'clock, and your working day would end at 1600 hours, then that time, when you're traveling during that time, it would still be your work. But after that, it would be travel time. So when you travel during your normal working hours, it's regarded as work time. But if you travel during your free time, what is regarded as your free time, normal free time, then it's not regarded as working time. And why this is important, the reason for that is that travel time does not is not counted in the hours that would, for example, entitle you to have overtime compensations. So travel time is usually compensated 1-to-1, if it is in free time. And here also, one thing that was also raised, and one thing that is also raised in European Union at the moment, is the right to disconnect regulation. They want to have a directive on this, and it would grant the workers the right to digitally disconnect from work without facing any negative repercussions from the employers. So that you could say that I will not answer any emails, I will not answer my phone, I will not even have them open in my free time, and nobody can say to you that you cannot do that. So that you can do whatever you want during that time and you don't have to worry about work. Because the thing is that, especially when it comes to senior staff, experts, and these are things that I think is also very good for you to think about as regards your own working time and your own free time. Do not open the laptop when you are having your time off. Do not look at your emails on the phone. So you are not, or you're not supposed to be required to be available or to be working outside the workplace and outside your actual working hours. So you can say that I'm now off. I will not do this. I know it's easy to slip there, especially when you're doing something really interesting. For the blue collar workers, it doesn't really happen that often when they just at a factory doing what they're doing. And then they leave all the stuff behind and they go home and they do what they want and they don't even think about the work. But of course, for senior staff and experts, it's a little bit more trickier. You are working more with your thoughts and coming up with ideas. And then you all know that when you wake up in the middle of the night and you have a good idea about something, and then you are not actually working, but your brain is working. So it will help with your work in that sense. But the line is more difficult to draw, but try and do that. And you will have to write more according to the new law. Then about the actual working hours and how they go. First of all, we have to look a little bit into the Employment Contracts Act in Finland, which is the most important law governing all of this. And here it means that also this law, Working Hours Act, also applies to workers who are working for employer under an employment contract. Otherwise, it is not applied to them. And in order for you to have an employment contract, 5 criteria needs to be fulfilled. So first of all, it needs to be entered into by an employee that is agreeing personally to perform work for employer under the employer's direction and supervision in return for pay or some other remuneration or compensation if you wish. So it has to be employee, that you will yourself do work for employer under employer's direction and supervision, and that you will get paid for it. If one of these 5 criteria or these 5 criteria is missing, then you will not be covered by Working Hours Act, and you will not be covered by the Employment Contracts Act. So that is the basis for all laws, employment laws in Finland to be applied. It has to be the 5 criteria fulfilled. And Working Hours Act does not apply, and this is the new scope that was a little bit tweaked. It does not apply to employees whose working hours cannot be determined in advance and whose use of working time is not any subject to any supervision, and who may thus themselves decide their working hours in relation to the following. The work is considered management work. They are managers of an independent part of undertaking, company, corporation, foundation, and that it's in connection to their relevant duties and in connection to their position in the company. And this is meant to be a very narrow interpretation, and it has to be and it should be applied only to very high level workers. Otherwise, you are in the scope. And the Act does not either apply to workers who, owing to the specific characteristics of the activities concerned, the work is performed in conditions where the work cannot be considered, or the supervision of the working time cannot be considered as a duty of the employer. And if you're asking now for some example of this, it's really hard to think about any, but maybe it could be a traveling salesman or something like that, who is always traveling, meeting up with clients, doing work here and doing work there. So maybe they could be outside the scope of Working Hours Act, but in general, the law should be applied to all at the moment, or to as many workers as you can and as you wish. And time spent on work and the time an employee is required to work and be at employer's disposal. And this is regarded as working time. So you are doing your work and being at the employer's disposal. This means you are working. And also Flexi Work, that I will talk more closely about later on, is regarded as work as well as remotely working or teleworking. So these are not outside the scope of the Working Hours Act. In the old law and in the old legal praxis, it was that the employees will need to be present at the place of work. But of course, nowadays it's more important. And this was the emphasis with the new Employment Working Hours Act, was that it's most important to get the work done, and it should not be so heavily tied to the place where the work is performed. The company wants results, and when they get them, they are happy. That is how it's supposed to be. And like I said, travel time is not included in working hours unless it constitutes also at the same time a work performance. And this can be, for example, if you're traveling on a train, traveling on an airplane, and you're working at the same time, then it's regarded as working time. But please talk about that with your employer. So if you put that as working hours, somebody can raise a question about it. So it's easier if you ask in advance what you're supposed to do with it and whether you can mark it up as working time. For example, when I'm trying, I'm often on a conference call or something. So even though I'm traveling at the same time, so if I'm on a conference call talking about something, then it's working time. And nevertheless, travel time can be otherwise compensated 1-to-1 according to a collective or employment agreement. But in some cases, maybe in most cases, but let's say in some cases, for senior salaried, for experts, travel time is somewhat compensated or it's not at all compensated. So it's a thing we always try to get into our collective agreements, that it would be automatic, but it's difficult because for salaried workers and for blue collar workers, it's usually compensated straight away, so they don't even have to fight about it. But for the senior salaried and for the higher level experts, it's a tricky question. But talk with your employer about that and ask how it's done. Ask about it from your shop steward at the workplace, or raise some questions about it. So it can be that there's something decided on that. Standby time, being on call elsewhere than at the working place. Because if you are on call at the workplace, it's regarded as working time. But if you are somewhere else and you have to travel really fast, there was just a recent case from the European Court of Justice where a person had to be on the job in 2 minutes, which is not a lot. So they actually had to be at the workplace in order to be there in time to start working. So that time was regarded as working time. But otherwise, a normal working time begins when you start the actual work. And before that, it's on-time call or being on call, or standby time, I mean, or being on call. And if you have to be on call and you have to be sober or something else, and you have to be ready to start working in a certain period of time, then the employer usually must compensate for that. And that's also something you need to talk with your employer about. But otherwise, general provisions about the working hours. Regular working hour week in Finland is 40 hours a week and 8 hours per day. But usually working hours for people working in offices, it's 37.5 and 7.5 hours a day. And usually people who are working 8 hours a day or 40 hours a week get this extra holiday, which is called Pekka's holiday. And they are from 80s when there was a minister called Pekkanen who introduced this model that if other people are working full-time with 37.5 hours per week and others are doing 40 hours per week, usually 40 hours a week are done in factories and in blue-collar work, when they have to make the shifts run smoothly or so forth. So he introduced that this is unfair, that some people are doing so much more work than the others. So these people get around 800 hours of extra holiday per year, which counts to 12.5 extra days of holiday. So if you're working 40 hours a week in Finland and you don't have these extra holidays, please go and ask why you don't have them and how you could get them. In some cases, you are not entitled to them, but it's definitely a thing worth looking into. And then we have flexible working hours, and it means that you and your employer can agree on flexible working time, which means that within set limits, you can start working later or earlier, or you can do longer days or shorter days. So it's flexible, and it can be, for example, from 6 to 9, and you can start working from 3 to 6. But for experts, it's usually much more flexible than this, and it's usually again that you get the work done. For example, I am a night owl, so I love to do work at nighttime. But then morning is really difficult for me. So my boss never complains if I send him emails really late, because he knows that for the next day I tend to wake up a little bit later. So it doesn't matter. I'm just using my natural instincts on working, and I'm really, really grateful that I don't have to wake up really early, because then I would lose something like 3 hours in the morning just to cover up from waking up early when compared with going to bed late and doing the work before I go to bed. It's very efficient. It's my most efficient time. So these things can be taken into account when talking about these things, and there is no one size fits all like it used to be. Like for me, the most horrible situation would be to start working every day from 8 to 16 or to 4 p.m. That would just kill me. So this flexibility is just really good for me, and I think for most of the people. But if from 8 to 9 to 5 or from 8 to 4 suits you, feel free to do it. It's really good. And then when the working hours are flexible, you can sort of accumulate the hours that are extra into the saldo, like said here. And then the saldo is supposed to be used in a way that you will spend also the hours away from the saldo. And usually the saldo can be like minus 20 hours and plus 40. Or it can be plus 80, or I know places where it's plus 120, which are quite a lot. But one thing for you to remember about the saldo, they are hours. The hours in your saldo are hours that you have made. So if the company has like a cutter that will cut the hours that you have in your saldo away, in many companies it happens like the last day of March. So the last day of March, you have 200 hours in your saldo, and 1st of May, 1st of April, you have nothing. This is illegal. They are your hours, and they cannot just vanish. So the company has to move the hours from the saldo to your working time bank, or they have to pay the hours to you in some way, or they have to let you take the time off. So they cannot just vanish because they are your hours. So if they are vanishing, or if they keep on vanishing, keep the papers or the working time reports and contact us so we can start looking into it, what has happened to the hours, and if they have not expired, the claims for those hours, we can take the case up and start asking for them. And also, saldo can reduce the hours, or you can keep the saldo away as free time. But it's good to agree on the specifics here too. And for example, that you can have full days as holiday, so you don't have to just have a few hours. I know some companies that used to have a system where you could never have full days as saldo holidays, which was just crazy. And some companies had a rule that you cannot have Friday or Monday free on saldo holidays. That was totally bollocks. So check that you can have them whenever you want, and full weeks, full days, Fridays, Mondays, what have you. And then we have a thing called additional work, and this is to do with the normal working week being, I can't find it anymore, but the normal working week being 40 hours. So the time from 37 hours to 40 hours, it's called additional work. And it also refers to work done on employer's initiative, but it does not exceed the regular working hours. And daily, it means half an hour added to your normal day. And overtime work and overtime compensation only begins after 8 hours a day or 40 hours per week. The 2.5 hours between that is additional work, compensated 1-to-1. And after that, only you can be entitled to overtime compensation. And one thing here that I have to raise is that if you work like many experts and senior salaried workers, they do a lot of work in the saldo. So they don't even dare to ask for overtime compensation. They don't get the overtime compensation. And of course, this means that people are losing money or free time in the course of that. But if you have a situation where you cannot do your work in the normal time, ask for overtime, because overtime that can be compensated according to the law has to be done only by employer's request or by employer's initiative. So you cannot do overtime work by yourself and by your own initiative. But even if one thinks that they can do overtime work by a compelling reason, which is also called silent approval, it is always good to ask for a confirmation that you can do overtime work in advance, for example, via email. And this silent approval can, for example, apply to a situation when you're doing installment somewhere and you know that the installment has to be done by Monday morning when people come to work. So it has to be done. So then you will do it, and that will be overtime. But please do ask for the approval in advance, or for the confirmation that you can do it in advance. Or in some cases, there will be liquidated damages if the work is not completed in the time asked or required. So in that case too, if there will be a liquidated damages is hanging on top of your head and on top of the employer's head, then it's usually the silent approval and you have to do overtime work. And also, if you need to have the employer's consent, also your consent is required each time when overtime is required. And overtime work cannot be agreed upon in advance. So this means you cannot agree, in your employment contract that you will do overtime work in future. It can only be done for specific cases, or for the certain cases, case by case. But in certain situations, a manager, a lower level manager than the one that is out of the scope of the Working Hours Act, is entitled to agree on a lump sum agreement that their overtime and some other additions to your salary are paid in a lump sum in your monthly salary. On top of that, never agree on that kind of lump sum that is in your salary, but it has to be on top of that, sort of like a percentage on top of that. And if you agree on that, but this is mainly supposed to be for the managers and for the flexi workers and not for anybody else. But many people do this nevertheless. But in that case, if you agree on this kind of agreement and the lump sum payment for your overtime work, please make sure that it's corresponding with the actual hours that you're doing, and that the compensation, the salary you are getting for it, is also correlating with the hours that you do and with the overtime additions. So if you have like a period of time when you survey your time, how much you're doing work, and if it comes out that you're doing in average overtime work, let's say 10 hours per month, then it's good to add the 50% to that in the lump sum, so you get it with the additions. And the maximum amount of overtime during a 4-month period is 138 hours, and 250 hours must not be exceeded in a calendar year. If this happens and you're working more than this, the health and safety supervisors will get in touch with your employer. They can do random checkups or something like that, and it's really bad if the company gets caught up with gets caught red-handed doing that. But of course, in the modern day, the overtime and the saldo, they are muddled. So I know people who have hundreds of hours in their saldo and nobody looks at it, which is sort of like getting away with the crime. I was just talking to a lady a couple of weeks ago, and she said that she made in a year and a half 800 hours to her saldo, and that's way too much. And then she got really sick. So don't do that. And then something about the flexi work. This was a new thing that came into force last year, and it means that you can do 10-hour days and 48-hour weeks, but it has to even out to 40-hour weeks during a 4-month period. And this will require a specific written agreement between the worker and the employer that you can do this, and it can be terminated with a period of notice if you don't like it. You can terminate it, the company can terminate it, and then you get back to working normally. Should mainly be used for knowledge work. senior expert level work, where at least half of the work is the kind of work which one can do anywhere and anytime. And like said, has to apply to over half of the work. And it cannot be agreed on a work where the employer regularly determines the time and the place of the work. Like customer service on employer's premises. In that case, it cannot be flexi work. And flexi work agreement has to cover at least the following: the days the worker is allowed to work, the placement of the weekly rest period, possible fixed time, which when you have to work, which cannot be placed between 23 and 06. So nighttime has to be or should be out of the scope. But of course, many of us, I think, work at nighttime too. If it's easier for you, but you don't have to tell your employer about that. And then you can do your work anywhere at any time, and the employer just interested in the results again of your work. But still, working time has to be monitored, and the working time register has to be kept. But in this case, you will announce your own working hours, so the company is not keeping really close tabs on you, but you have to keep tabs on yourself, and you have to report back to your employer the hours that you have been working. And it's very important, if you're thinking about this, to make a good agreement on this. And this is a local agreement, so to say. And like said, it can be terminated with the period of notice of 3 months. And then you will go back to working normally. And the other party cannot force the other party into this model. And this whole settlement has to be voluntary. On voluntary basis, you can either do it or you don't have to do it. So the company cannot push this on you. If you say no, the company has to respect that. And like I said, you will monitor the working time yourself. And if there's less than 50% working time autonomy in the work, flexi time regulation cannot be applied. And then we have the tricky thing of compensation for overtime work. And like said, compensation for additional work, which is sort of the half hour per day, is 1-to-1. But after that, you will get compensation for overtime, but only in a case when you have the consent of the employer to do the overtime or the silent approval. So this has to be given to you in advance. It's really, really, really tricky to get the compensations afterwards, after you have done the work. Usually those hours end up in the saldo and they are compensated only 1-to-1. So for the first 2 hours from 8 to 10, you will get 50% extra for working. And then for additional hours after that, over 10 hours per day, you will get 100%. So it's actually good. And here I have overtime compensation calculator. And this is just a photo of it, but we can disseminate it to you. So you can start using that if you have any questions about it. So there we have the day. So it's all of the days there, and then you have the normal working time, and we can also make this to be applied for 40-hour working week. And then we have the working time, and this is where you can change you can change the numbers when it says normal and additional. Additional work is here with green. So if you do additional work, it just be compensated 1-to-1. And then we have the hourly rate down below. So you can also change the hourly rate to your normal hourly rate. And then you have the accumulation and everything that will add up. And then you have the overtime compensations and the cumulative compensations. And then you have the weekly rest, which is to do with having to work on Saturday. And if you work on Sunday, you will be straight away compensated with the Sunday compensation, which is always 100%. And if you always do overtime work on Sunday, you will get it maybe twice the money. And then there is also yes and no in Finnish, kyllä and ei, where you can put kyllä if it's a church holiday, and ei if it's not. So if you are interested in that, we can send it around so you can test it yourself how it goes, because it's very, very tricky, for example, to explain how Saturdays are compensated when it comes to the weekly rest periods, like it's here. And you can also agree on getting the overtime work in corresponding free time, but remember to add the 50 and 100% here too, and not be content with one-to-one compensation. And like I said, a special lump sum can also be negotiated, but only if you follow the rules that you have the observation period, and then you have the real additional hours accounted in. Daily rest periods, if you work more than 6 hours, you will get your lunch break. Lunch break can be 1 hour. But usually it's only half an hour, and then if it's half an hour, then it doesn't make your day longer. So if you would have 1 hour rest periods, then it would mean that your daily time at work would be 8.5, which we don't usually have. It's usually half an hour, the lunch break. And remember, if you work less than 6 hours per day, you are not entitled to your lunch break, but you are entitled to coffee break. Daily rest periods during one day, 24 hours, you should be given uninterrupted rest for at least 11 hours, and there are derogations in the law. Look them up if you think this applies to you. And then the weekly free time, which I told you in the calculator, is also compensated, is based on this. So in 1 week, you are supposed to have at least 35 hours of uninterrupted free time each week, preferably around Sunday. So this is based on the fact that usually people work from Monday to Friday. And yep, so you have to compensate it for the derogations from the weekly free time, and like I said, it's easier to do with the calculator. And with Sunday work or on church holiday, which is Easter, Midsummer. Actually, 1st of May is not a church holiday. There is own law on that, which gives you the double the salary for that day, and also for the Independence Day, there's an own law which also gives you the double the salary for that. But church holidays are all the holidays that have to do with something biblical mainly. And for the Sunday work, or for the work on a church holiday, or for 1st of May, or for the Independence Day, you will get twice your regular salary, and also overtime compensation if you work on that day. And then we have one quite interesting thing, and I think this would be very much appreciated around Europe also. So these changes came into force in 2018, and they were meant to battle 0-hour working agreements or on-call work. And in the law, it's called variable working hours or variable working hours. And they used to be in a really, really bad situation, these people. They would not get any salary if they were sick. They would not get any salary or work if they were on the period of notice. They would not get the work if it was given to somebody else. They didn't even know what shifts they were supposed to be doing. Shifts were taken away from them, and they wouldn't be able to get any unemployment benefits because the company didn't have to lay them off or furlough them. So it was really, really tricky. So it can be only used, the 0-hour contract, if the working time on offer varies also in reality. And if working time turns out to be the same all the time and fixed to a certain amount of work per week, the variable condition is invalid and the working time condition must be interpreted as fixed normal. So it has to be also based in reality that you need to be on a flexible working hours scheme. And the worker has to be notified of the timing and the placing of the work now in good time, at least 2 weeks before. And if there's time in the shift plan for you and it's taken away, you have to be compensated for that if it's in the shift plan. If the actual working hours demonstrate that the agreed working hours clause has been agreed to be too small for the employer's actual needs for labor, and here, by the way, the 0-hour contracts is something between 0 and 40. And if you're agreeing on this kind of agreement, please agree on something minimum if you are going to be working something minimum every week, nevertheless. So go with 10 to 40, go with 10 to 37.5, go with 15 to 37.5, because then if there's no work on offer, you will still get the 15 hours of work paid to you if you are ready to work, but there's no work on offer. And if, like I said, the working hours do not correlate with the actual hours of work that is on offer, the employee can request a negotiating to amend the working hours clause, and the review period is the previous 6 months and requires the employee to be active. You will have to ask for this review, and you have a right to use an assistant in the negotiations. But if no agreement is reached for a new minimum working hours, and this means that the 0 is up to something, or 15 is up to 20 or something, the employer must submit a written statement why they were not able to give you the extra hours or change the agreement. So this is vital for you to remember. If this happens, change it or start the negotiations. So the company will change it, but you have rights to do something about that. And here, like I said, it's very important that you have something over the 0 if it's the reality, because like I said, if you are available for work and the company doesn't offer you work, you will still be paid for the hours. Because with the normal employment agreement, with the 37.5 hours per week, if there is no work on offer, the company has to pay your normal salary. Because the foremost duty of the employer is to pay your salary, and your foremost duty is to work. So the company's first duty is not to offer you work, but to pay your salary. So if they don't have to work, they will still have to pay you your salary if you are available for work. So this is why it's important to have that. And now you also would have your salary during the sick leave, which was non-existent in the previous years, which was really bad. And you would still be get your normal work hours or the salary for it if you have something in the shift plan or in the shift list. So you would, for example, if you have the list for next week and you have normal work for every single day, and you get sick on Monday, the company has to pay you your salary for the whole week. So that's really an improvement, and the rate for that time is your average daily payment in the previous 6 months, and this also works for the period of notice. So they also have to pay your average working hours according to your average salary for the past 12 months. And you are entitled to overtime compensation only when you're working over 8 hours per day. So if you never reach that, you will never get your overtime compensation. And then working time bank, a new thing in the law. They have been happening in practice, but not in the law. But now it's also in the law. And the agreement on working time bank has to be agreed upon with the employer and the shop steward or other elected representative of the workers. And in the agreement, you agree on how much time can be saved or transferred into the bank, only 180 hours per year, and how it will be terminated, period of notice if you want to terminate it, how to use the time, always at least 2 whole weeks per year or full days, and how to change the free time into monetary compensation and under what criteria. And then other provisions according to the Working Hours Act, the company has to keep working hours register. So they have to register all the hours that you're doing and also all the relevant compensations paid to you. And if you want a slip of that, they have to give that to you. And one important thing to remember, period for claims according to this law, for example, overtime compensations, they have to be done within 2 years of the end of the calendar year in which the entitlement arose. So I had a call last week from a guy who had overtime compensations from 2018, and I had to tell him that they are already expired because the claim period for that ended in actually on 31st of December 2020. Even though they were accumulated in the summer of 2018, but that is how it goes. So it's quite quick you have to be in order to get the compensations. And of course, now we are it's quite tricky even with 2019, because the claims for that year and for that year's overtime compensations have to be done by the end of this year. Otherwise, they will also expire. And there is the peremptory nature of the provisions. Derogations can be done by collective agreements only. And if you agree on something that is worse than it would be according to this law, it will be void. And it cannot be implemented in reality or in action. So this is, and also the penal provisions. So if something happens really bad, that the company is not keeping the working time register or something else, so the company can be sentenced for a fine over that. But that was about the Working Time Act, and then something about the non-competition and what happens with that. Non-competition, it sort of has to be separated into 2 boxes. So one box is competing activity during your employment. And this is applied to all situations when you are working and during your employment. And nothing else has to be agreed on for this to be applied to you, and you cannot agree this away. And competing activity means that during your employment, employees shall not do work for another party or engage in such activity that would, taking the nature of the work and the individual employee's position into account, cause harm to the employer as a competing activity contrary to fair employment practices. So this will apply to you. So this means you cannot start working for a competing company in your free time. And this means that you cannot start a competing company in your free time. And if the company catches you with this, you will lose your employment. That's for sure. They always get really mad when this happens. And there's really nothing I can do about that. And you will lose your job without the period of notice. It's usually like cut like that, and you're out of the company if they catch you doing something like this. So remember this. And also there's a clause on business and trade secrets. So during the term of employment, employee shall not neither utilize nor divulge to third parties the employer's trade or business secrets. And this will apply to you during the term of employment. And it's usually also agreed in a non-disclosure agreement that this will also be applied to you after you have stopped working. And then we have the non-competition agreement. And it means for a particularly weighty reason related to the operations of the employer, an agreement made at the beginning or during the employment relationship. This means agreement of non-competition may limit the employee's right to conclude an employment contract on work to begin after the employment contract has ceased with an employer which engages in operations competing with the first mentioned employer. And also limits employees' right to start such operations in his or her own account. And this agreement has to be concluded especially. And this means that even though it says for a particularly weighty reason, usually all of you are doing work that will be applied to you. Nevertheless, and that this can be applied to you. So there's not so many ways to get away with this non-competition agreement. And I have seen some really bad situations with these, where these are limiting the rights of a person to go and work somewhere else really badly, and it's not nice. And the criteria to be taken into account here when assessing the weighty reason include the nature of employer's operations, the need for protection related to keeping a business or trade secret, special training given to the employee by the employer, employee's status, position and duties, or a special clientele attached to the employee. And if you look at these, they usually apply to very many of us and very many of the senior salaried workers or experts or so forth. And at this moment, and in the future too, this agreement may restrict the employee's rights to a maximum of 6 months. And if employee receives a reasonable compensation for these restrictions, this period can be extended to a maximum of 1 year. And like I said, there are legal amendments on the way, and in this case they will be applied for the non-competition agreements. And here is one very important thing. Instead of compensation for loss of damages, which is the first option, the agreement may include a provision on a contractual penalty penalty or payment for liquidated damages, which shall not exceed the employee's pay for 6 months. And if you can have any say on this, always go with the compensation for damages if you can choose it. Never go with the penalty payment or contractual penalty, liquidated damages, because that's very easy for the company to go for in the court, for example, because it only takes that you will go and work for a competing employer. But when we are talking about compensation for damages in Finland, the employer who you are leaving has to show the monetary value for the damages in order to go to court and try and get them. So just to remind you once again, go with the compensation for damages if you can do anything about it. Unfortunately, the companies are aware of this, so it can be that they will not go for that, and they, for obvious reasons, really like the payment for liquidated damages, but it always pays off to actually try to do this and change it. So we don't have any case in Finland where the company has been able to go to court to claim compensation for damages, because putting the price label on that, it's impossible. And then the background for the law amendment, and also what it will look like. And this will sort of give you an idea how things are happening in Finland, lawmaking, how we are involved, and what we can do about it. So it's quite interesting, at least to me. But I'm a law geek. But it's been a long process, but it's proved to be quite good in the end. So the end result is something I will like. So the background for this is that there's this deputy judge, Jukka Ahtela, who is used to make reports. I actually don't know why they're using this guy for these, but obviously he's very talented. And he made this report in 2018 for the Ministry of Employment and Economy. But of course, this whole thing, our saga started already 2015, but it got better after this. And there was a study, and Ahtela's study proposed tightening of the criteria for the use of non-compete or non-competition agreements. And following this report, preparations were made for clear restrictions for non-competition agreements, and also Akava considered a total ban on non-competition agreements. And that would have been a preferred option, but of course we knew that it's not gonna really fly, and not really easily anyhow. And Akava in this is our confederation for senior salaried workers. And the rationale was that in order to support economic growth, there was a need for more efficient labor market, where the mobility of workers would not be or should not be restricted as it is in the current law. And the background for this was also that these are done. I will actually show this slide before the other one. In recent years, non-competition obligations have no longer been limited to key executives in companies, to top management or top experts, but have become more widespread in contracts for all categories of employees. And I have seen and heard about non-competition agreements for workers who are actually on the shop floor or working in a factory, and they have no idea what is happening on the higher levels in the company, and they have no idea about the trade secrets. But because it was easy to use that, easy to tie people to the company with the liquidated damages of equivalent to 6 months salary, so they were doing it. And a study, well, I will go into that later, but the same pattern also applies to non-disclosure agreements, confidentiality agreements, and in this case, they are even worse than is the situation with the non-competition agreements. And non-disclosure agreements have to do with your right to mainly start your own company, and non-disclosure agreements are mainly to cover the trade secrets of the company and how to protect them. And what I gather, I think we're going to have a course on that later on next year. And the contractual penalties when it comes to non-disclosure agreements is not restricted to any amount of money. It can be anything. And in Akava's research, the biggest liquidated damages for non-disclosure breaches was 1 million euros. So it's actually crazy how much money can be involved here. And people are, of course, scared, Richard, to do anything if they have these kind of numbers in the agreements. And of course, we can ask, why are they agreeing on these in the agreements? But sometimes the balance of power when you're agreeing is not that clear. So you just go with what you're given. And in this Ahtela report, there was nothing on non-disclosure. And unfortunately, it is not moving on, at least at this moment. So something has to be done for the non-disclosure agreements in future. And the report did not analyze either why we need overlapping non-competition and non-disclosure agreements, as is the situation now. So we don't like it, and something has to be done with it. So they have to be kept separate and not overlapping. So you have 6 months salary here as liquidated damages and 1 million euros here as liquidated damages, and then you have them overlapping. So you don't even know what you can do in which box. So the proposals for this was a clear disappointment for us. And all in all, the studies that we have made show that more than half of the employment contracts of the members of Akava include a non-competition agreement, which is bad. And according to the study that we made, the non-competition agreements, and especially with the contractual penalty, liquidated damages, have a significant effect on how we will dare to change jobs. And this, of course, makes the labor market more mobile and immobilized and rigid and not so agile. And in general, all studies show that overly grave non-competition obligations make it more difficult for workers to change jobs and for the companies to recruit from other companies. So everybody's in their own little bubbles or boxes and nobody's moving because it's too risky. And in addition, all risks of violating the provisions of the law are borne by the employee, especially with the double agreements that was mentioned before. So the situation is not at all ideal. And the matter, like I said, was raised already in Sipilä government. He was the prime minister before our prime minister now. And but it took a leap forward with the new government proposal, or not government proposal, but government program, when it said non-competition agreements, the use of non-competition agreements and non-competition obligations during employment is limited by clarifying the legislation, or should be limited by clarifying the legislation and providing for sanctions in a balanced way for the use of non-competition obligations. And this was a good statement, stating a little bit what we wanted. And the working group started its works immediately in the autumn of 2019. And in the next spring, 2020, last spring, the result was ready, and it included the following. It included a statutory compensation for the employee as the aim, with the aim of improving competitiveness to reduce by reducing the number of non-competition agreements. And it was also suggested that non-competition applications should be included in the contracts only for key employees and for very compelling reasons, and that they should not be so widely used. And the main aim is and was to reduce unnecessary and routinely made bans on competition that are just limiting everybody's freedom. And of course, these non-competition clauses are restrictions on fundamental rights in Finland. So they should be interpreted in a very, very limited way or restricted way, but it's not the case at the moment. But according to the working group's proposal, the employer now has an obligation to pay a compensation for the employee for the period of non-competition after the employment has ceased. And the employee should be compensated on a percentage basis, and the amount would depend on employee's salary, and the agreed length of non-competition agreement application would be as follows. For 6 months compensation, for 6 months competition agreement obligation, the compensation would be 40% of your normal salary, of your latest salary. And if the limitation period is more than 6 months, the compensation would be 60% of your salary. So what to remember here, if you will have in future, or maybe even now, non-competition agreement for less than 6 months after you stop working, and if you stay at home and you are waiting for the right to go and work for another company, you will be compensated 40% of your normal salary on top of the unemployment benefit. And if it's more than 6 months, it has to be 60% of your salary on top of the unemployment benefit. And the ban again can continue only for maximum of 1 year. And the compensation should be paid to you on your normal salary day, based on your normal salary when you terminate your agreement. And a new issue in the law, on top of this other regulation, is the employer's right to dismiss this clause. So if the employer wants, they can terminate this non-competition agreement in accordance with a notice period, which should be at least 1/3 of the length of the agreed non-competition application, but not less than 2 months. And the company cannot do this after the employment has been terminated. So this means that if the company wants to terminate it, the period of notice is usually 2 months. So if you resign in that time, you will still get this compensation, but after 2 months, if you resign in that time, you will not be compensated. And Yeah, there's something about the other countries, Nordic countries mainly, who also have this compensation. In Sweden, it's 60% of all the time. And in Norway, the compensation is full salary, full pay for the whole time, which is really good. But we went with the Danish type model, which is like said. And the matter was under discussions until 22nd of May this year. And then it sort of stopped. And we didn't know what was happening with it. And the Minister of Labour, Tuula Haatainen, has been doing something with this with her group. What we didn't even know then what was happening. But we were keeping a keen eye on it and trying to influence it. Which we have been doing all the time. And amendments will be made to Employment Contracts Act. And the law should come into force the 1st of January 2022, so quite soon. And there is a new regulation that will also apply to old non-competition agreements. So if the company do not change it, there's a compelling legislation that will be applied to all of you after one period, transitional period of 1 year. So if you are quitting your job or the employer lets you go on personal related grounds as of the 1st of January 2023, you are entitled to the compensation even though you don't have the clauses in your own employment contract. And one thing for you to remember here, if the company lets you go on production related and financial grounds, you will not be covered by the non-competition agreement anymore. So you will get rid of that. But if the company lets you go on personal grounds, so you do something stupid, then non-competition will be applied to you. So that's usually the worst case scenario. But even in that case, you would be entitled after 2023, if the company doesn't change your agreement and you have that already, into this system. So that's quite vital for you. And this is all I had to say. I say thank you, and I hope you found something, some bits and pieces in my presentation that you can use in your own working life. So I wish you a good day, and you can contact me if you have any other questions. Thank you.
Thank you, Maria. And thanks to you all who joined us live here, and thanks to you all who are watching this recorded session afterwards. Yeah, this is it. See you soon somewhere else. Bye.
Bye-bye.